you go. Well, thank you very much, Catherine, for that those kind words, that nice introduction, and for humoring me on the book raffle. Always trying to get the information out there. I really appreciate this opportunity to come and talk to everybody this evening. I can honestly say I've trained IAP 2 people coast to coast now, so it's good to be here. Our presentation, we're just going to talk to you a little bit about Aboriginal engagement, and we've already heard the sort of biography. I have been doing the work since 1994, started doing it for Hydro. Didn't join Hydro to do the work. I actually just wanted to start at the bottom and claw my way to the top like everybody else. That was the plan. And joined in 91. By 1994, I was working in Aboriginal relations and had a chance to sort of go through the big build phase of Aboriginal relations and get to see a whole bunch of different tracks in terms of relations. And my primary responsibility was Aboriginal awareness training, but we also ended up doing consultation training, and I worked in communications and business development, workforce development, negotiations. So it's just really a really neat opportunity that way, and I think probably a lot of the things I learned about Aboriginal people and issues and how to work with communities really would have that would have been the bedrock sort of foundation piece for me there. So as with all of my other presentations, if you've had a chance to sit in, my job here tonight is to present you with background information, a little bit about people, a whole bunch about issues, try to tie it together with the engagement piece. There's you can talk about this stuff for a whole day and still feel like there's another day or two to keep going with it. I like it when we ask questions and make comments and statements. You can do that anytime during the presentation. I think I've heard most of the questions you'll get now and have had a chance to prepare answers, so please feel free to jump in and ask questions. If you're worried about how your question might sound, you can always throw a, what do you say to those people that say this, Bob, in front of it, and then we'll know it's somebody that you met at one of the open houses recently. My goal is just to try to create a safe space for people to really get a sense for the engagement piece. Cell phones, I know you already did this, but in the quiet mode, and copy of the presentation, which people always ask me. So the microphone isn't for noise. I'm recording the presentation. I've got the slides already prepared. I'll be uploading everything, and I'll give you a URL address at the end of the presentation where you can go find all of this stuff so that you have a copy of the presentation. The presentation that we're going to give you tonight really was driven by the survey, which Catherine was kind enough to circulate to members and active and non-active, I hope, and we did get some feedback about the interests that people wanted to hear about in terms of Aboriginal engagement, so that I just took the feedback from the survey form, sort of laid it down and thought this would be a great agenda. This is what I'll try to cover in our, I know we're supposed to be out of here by 11 o'clock, so we'll try and make sure that that happens. And in the survey-driven topics that people shared, I thought there was some really good stuff. People were looking for engaging in a respectful, effective, and successful way. I thought that was one of the big challenges that somebody put out there, so I thought, oh yeah, we can talk about that. Building organizational support for Aboriginal consultation and engagement. It really does take the organization today to be able to be effective. Hints and tips for when you're in meetings. We can definitely help you with that. I can remember going to some pretty tough meetings with communities way back in the day, and so how do you sort of handle yourself and set the table, and we'll definitely touch on that. People were concerned about unintentionally offending people, saying the wrong thing and not being respectful, so we definitely got some good stuff for you there to help out with that. And the big $1 million question, actually it's a $1 billion question, how do you know when your Aboriginal consultation and engagement is effective? And so there's some fun stuff that we can go through there. We'll definitely help you out there. Dealing with difficult questions. So one of the things that we have to realize when we are working with Aboriginal peoples and communities, because of the way the law has evolved in terms of the duty to consult with Aboriginal peoples, a typical community, Tsleil-Waututh Nation, will have anywhere from 400 to 700 referrals in a year. And those are referrals from big companies. Hydro might send a referral to them about a new power line, which would require 40 hydro people to go and talk to them. So literally they are bombarded when it comes to the Aboriginal engagement piece. And so sometimes we get asked the tough questions just to see what you know and if you can sort of pass muster. They want to see how you are going to approach policy. So we'll talk to you about some of that in terms of the difficult questions and how to sort of deal with those. And then one really I thought was a great specific question: how do you balance the interests of leadership with the community? And so I'll give you a frame of reference that'll help you try to sift through some of that stuff. So in terms of the presentation, those all came in sort of all different ways, shapes and forms. And so I thought I got to organize this in some way that it'll flow nicely and make sense. And so I thought the first thing that we would tackle to be successful in Aboriginal consultation and engagement really was that organizational commitment piece. You have to find out whether you're going to be a lone wolf or you've got broad sort of policy and support behind you, because that does make a big difference. And in terms of building organizational commitment, I thought I'd share with you just a business case. This is something that you would have to be really good at in terms of making the case when you're talking to the executive and to senior management, in terms of getting the mandate to do the things that you're going to do and ask them to do to be able to move forward. So the business case became a really crucial piece of our work at Hydro too. When we first started going out to people and saying, we want you to build relationships, sometimes they would say, well, why? Why do we have to do things differently for these people that we don't do for everybody else? And so the business case really helped to solidify that for the employees corporate-wide. And we were looking at it from sort of three main perspectives: risk management, reward enhancement, and social responsibility. And so if we take a look at an industrial developer's business case, some of the risks that have to be addressed with the engagement and will drive the approach and the process and the things that are going to motivate you. When we're dealing with past land resource use, so Hydro built stuff in the past, did it infringe on Section 35 rights? And if it did, how much would a court order it to pay in terms of accommodation? It's a very serious legal risk and financial risk for the corporation. And so whenever we're looking at our consultation efforts today, we do think about, well, what did we do in the past, and is it going to come back and haunt us this time, or can it come back and haunt us in the future? So we wanted to definitely touch on that. Present land use and acquisition. Pretty much nothing gets built without having to talk to Aboriginal peoples. That's just the reality that we're working with right now. The law continues to evolve weekly sometimes, and so we have to be able to sort of follow all of that as we're doing our present land use and acquisition, and try to sift through what to do and what not to do and how much. And new nation-to-nation treaty arrangements are going to change fundamentally the way we work with on the Lower Mainland here, Tsawwassen First Nation with the new treaty, Malnuth on Vancouver Island, the Niska in northwestern BC. Those treaty arrangements can present big risks if we don't consider them that in the first place, and then we need to sort of plan our strategy, our engagement strategy, to really be able to function in a world where quite possibly they could become a new kind of landlord, somebody with a whole different set of rules and regulations and all of that kind of stuff, and legislated both at a federal and provincial level. So we have to think about our engagement in those terms as well. Reserved land access, probably the hardest thing you can do today is try to get access to reserved lands. It requires 4 federal agencies. You need to go talk to the band first, then the band invites the Aboriginal Affairs and Northern Development Canada folks. Before they can do anything, they've got to bring in the species at risk assessment folks, so there's 2 federal agencies. Those folks are going to notice a fish-bearing stream somewhere nearby. That's 3 federal agencies. And before they'll do anything, they've got to bring in the Department of Justice to see if they'll, if they approve this thing with the band, will they get sued in 50 years, and how much might they have to pay? So it becomes really complicated really quickly when we start talking about reserved land access. And certainly a number of First Nations have already began to move into the space of taxation. So they're going to be taxing for infrastructures, road, power lines, facilities sitting on reserve. So it is something that we have to think about, both on reserve and outside of the reserve. There's a lot of communities looking currently collecting stumpage fees. The Nisga'a Nation were able to collect stumpage fees as a matter of their Section 35 treaty rights. So it's being able to look at some of that stuff. Yes, please.
Taxation, taxing who?
In terms of, so if we looked at the forestry example, the Nisga'a will collect stumpage fees from forest companies that will do logging on Nisga'a lands. So that's going to be, that would be for industrial developers. Mining, you could look at mining royalties and water rights and all that kind of stuff. In a more urban setting, we see a number of First Nations in the country ending up with property taxation. So West Bank First Nation, Kamloops, Penticton Indian Band, the Soyuz, they're getting into the space of property tax. So there's 8,500 non-First Nations people living on West Bank lands paying taxes to West Bank First Nation for residential real estate properties. And then in terms of just transactional taxes, GST, BST, PST, HST, whatever taxes happen to be out there, Tsleil-Waututh is a taxing First Nation. They collect those taxes, remit them to Ottawa, they come back, and so it's the whole spectrum of tax, and we have to be thinking about that in terms of working both on, particularly on reserve land to start with, but I think at some point in the future we may be bumping into situations where they're going to be contemplating taxation as part of treaty settlements. They already have. It's a current reality today, and I can't say anything that would change that. So I'm not with the federal government though, so I can't give you a definitive answer. I just kind of look in the crystal ball of like a Nisga'a treaty and say, what are we doing now, and can we expect to do more of it? That's sort of how I think about that stuff. But it is part of that risk management thinking that we have to share with our teams and our companies to say, hey, we got to be thinking long term about our engagement. Short-term win and engagement today just doesn't help you long term, so that's going to be part of the work that you'll have to get out there. New nation self-government arrangement is going to fundamentally change the way we relate to neighboring First Nations. They're going to have legislative authority. The Nisga'a can pass their own environmental assessment legislation as long as it meets or exceeds other standards of environmental protection. So it's the treaty is sprinkled with these general sort of application clauses. They can do stuff as long as they meet these laws of general application. So if you could start a process, you could be in the middle of a power line, and they could start increasing the responsibility on you to do more in terms of environmental protection and environmental assessment. So that would be sort of a risk assessment thing to be thinking about in terms of the engagement. Maintaining existing plant and equipment, if you've got power lines or trees or roads or any of that stuff, you got to go out. You're always consulting. It just doesn't. We do more and not less, which is why the Sustainable stuff is going to become so valuable. If you guys haven't already signed on, I think that's going to be a place to go in terms of fulfilling those legal and regulatory requirements, which, by the way, are always changing. And they're a risk because from an Aboriginal people's perspective, and that's First Nations, Inuit, and Métis, when they're not happy with some project, that's one of the things they'll do is wait for the regulator to come through and say we haven't been adequately consulted, send you back for another 2 years of consultation. So that's why we call it a risk. It's low-hanging fruit if you're looking at it from the First Nation side of stuff. They're definitely pay a lot of attention to that. If we do a good job in terms of managing all of those different risks, really the name of the game for a lot of organizations, governments especially, businesses, is continued access to lands and resources. That's what you'll get if you can do a good job. It'll just get tougher and tougher if you don't do a good job. We can help address long-term employment challenges, take advantage of new nation-to-nation treaty arrangements. So good consultation now has value in the future. If they like what you're doing and how you're doing it, it'll be easier to expand. They'll consider doing stuff with you. So that's just sort of the thinking that goes there. You'll be able to take advantage of those new nation-to-nation treaty arrangements. You'll be able to deal more effectively with Aboriginal self-government structures. Probably the big one, and this is in terms of building that organizational support, which was, again, on the survey rated quite highly. The big sort of metric that everybody uses to justify more consultation and engagement is really the legal stuff. if we do a good job of consulting, we'll save ourselves from a $30 million court case that we might win, but will take us an extra 2 or 3 years of our stuff being tied up while it's being sorted out. That's really the thing that certainly the executives respond to in terms of asking, we're going for a mandate to do more consultation and engagement with communities, and that's just something that sort of resonates across the board with Aboriginal peoples. Protect and enhance the organizational reputation. So I've seen just on the announcement of court cases or blockades, share prices start to take a tumble for those private sector companies, and it could be quite substantial, $3-4 over a weekend with a good negative media campaign. And so the reputation, shareholder value, if we do a good job of doing all of that, of course, we can take advantage of social responsibility values. We can do better reporting in terms of our CSR, our corporate social responsibility, and we can meet the financial requirements of lenders. So it used to be just the World Bank that cared about this stuff, but it's right into the domestic lending and green and social lending markets as well. So those are some of the rewards and part of that building that mandate internally for a better, more deep consultation and engagement piece with Aboriginal peoples. How do I know if my consultation is going well? I've got a good answer for you, but I'm not going to give it to you. I'm going to actually throw it back out to you guys just for a second, and I'll just change it up a little bit because I think it'll help you with sort of the rest of the presentation here. And this is one of the things that if you've taken our day-long consultation training, we ask you to really wrestle with. And what it is what do you think the goal of Aboriginal consultation is? And if you can answer that question, then the rest of it kind of becomes easy. But you've got to understand the goal, and so we'll throw it back out, just groups of 2, 3, 4, whatever, how self-organize, and take a minute or two just to try to tackle that from a engagement, public participation perspective. What's the goal of consultation? This side of the room, put somebody out in the spot here.
Well, I was thinking about a project that we did in Yellowknife, and we were engaging a lot of First Nations in that process. And the thing that I learned was, do we have permission to go to the next step? And when you have permission, what we found is you have to qualify to go to the second phase of the process, and that there's a certain pace of the dialogue that happens with Aboriginal, the way they want to be consulted, that you can't rush things. The whole Western way of just pushing things through is really the opposite of what and everything is allowed to breathe and take their time. And so we took this viewpoint of, we have to ask for the audience's permission. Do we get to move on to the next step? And that, just asking that question, I think, shifted the opinions of, oh, okay, so this is not being shoved at us. It's being allowed to take its own time.
There you go. I like it. So we're definitely starting to touch on sort of the nuts and bolts of the Aboriginal engagement piece. One thing that really does make it good. Yeah.
We like the humor.
So they're good questions, though, and fundamentally at the core of public participation with Aboriginal peoples is sort of this legal twist. It's like just a little thing that differentiates them from everybody else. And so you can spend a lot of money looking for legal direction, and honestly, still on the consultation stuff, give me 5 lawyers, I'll give you 5 different answers to these questions. When have we done enough? When is it meaningful? That kind of stuff. And so if you're asking those questions, it's a tough way to start out your engagement. You're probably in a better headspace if you're going, how do we get permission to go to the next level? Because that's when you really do know you're making headway, that you're not going to get pulled, they're not going to pull a judicial review to stop your project in its tracks for 2 years minimum, right? That's what differentiates them. What's that?
Or send it to dispute resolution.
Or send it to dispute resolution. Is it safe to rely on the Crown? So there's another good question I get asked all the time, especially from the private sector. And I'll just tell you, there's been 150 court cases of duty to consult because the Crown was perceived by First Nations to have not done a good job. That's what over 150 court cases tell us. A large number of those court cases really focused on the adequacy of the consultation, and a small number said we didn't have to consult at all, and those ones got creamed, right? So you'd never go in and argue we didn't have to consult. Those are the ones that paid the sort of the legal price, and then the rest the courts wrestled with adequacy and meaningfulness and that kind of stuff. So they're great legal questions, but to put a better picture on it, and this is the test that Aboriginal peoples use. They're sitting on their side of the table, they're talking to practitioners. What they're looking for is for Canada to live up to its Section 35 commitment. So we've got this constitutional commitment, which says basically in Section 35(1), we hereby recognize and affirm the existing Aboriginal and treaty rights of the Aboriginal people in Canada. So that's the goal. We got to recognize and affirm. The duty to consult stuff, if we were to think about consultation and the Constitution, they're kind of the heads and the tail of the coin, right? The Constitution would be the head side, the tail side would be this duty to consult piece that says we're supposed to avoid the unjustifiable infringement of constitutionally protected rights. And if we can't avoid them, then accommodation is normally required. So that's sort of the quick answer. So I always tell people the goal is to avoid the unjustifiable infringement of constitutionally protected rights. Hang on to that answer because some of you had some good answers, good questions on the survey, and I'll tell you how to answer those questions with just that one little nugget. And I think it's something that you have to take with you too, because if things get really bad, you're going to get called back into the court 3-4 years down the road, maybe even be retired. They're still going to call you back. And the judge is going to look at you and say, so Bob, what were you trying to do? I mean, well, I had 38 meetings. Yeah, but Bob, what were you trying to accomplish? So, you know, you look at the whole shale gas thing, we'll pick on the guys way out on the East Coast because they're not here to defend themselves. But you've got a premier over there, well, we've done more consultation with this group than we've ever done with anybody.
Wrong answer.
It is the wrong answer. You know what? If you want a judicial review, answer that way, because that's just fodder for judicial review, right? It's like, yeah, well, but what were you trying to do with those 38 meetings? Well, yeah, we met and we told them what we were going to do, and you know, you're just going to be fumbling around. What the judge wants to hear, or the judge is, well, Your Honor, our goal was to avoid the unjustifiable infringement. From our perspective, Your Honor, that meant getting permission. If your company's in that situation, then you're good. They'll support you. The courts are just going to support people. Right now, what we've seen in all of those cases is they're supporting the people that have tried the hardest. And that can be, sometimes they'll, you know, give the whip to the government. Sometimes they'll spank the First Nations or other Aboriginal peoples. That's what we see happening. And so keep that in mind. Section 35, constitutionally protected rights. That's where they're coming from. That's their headspace. They're different than anybody else we publicly participate with. And so to engage in a respectful manner, then, or in a respectful and successful way, definitely requires us to do, in the book we put together this respect model, research, evaluation. We have to come up with strategy. And then we go in and we do our whole presentation piece. That could be open houses and all of the stuff that you guys are good at. But you need to be thinking about this. And the research piece, what we want to research is, okay, we're thinking about forestry. What kind of rights could impact, our forestry could impact what kind of rights they might have. The worst thing you can do in public participation is go in and say, can you tell us what your rights are? Because we don't want to infringe on them. It's the worst thing you can do because now you've got to go through a listings process and then you've got to give a rating and scale piece. And what you really want to be able to do if you want to be successful and effective is do a bunch of research yourself. Bob, I don't have time to do the research. We're busy over here, man. We got no time and no money, and you're gonna spend time. You know, you could get 6 months into a process and realize you're talking to the wrong people, which you could have found out in 20 minutes of research on Google. You get to spend time. So definitely commit to the research piece, the evaluation. What's the story they're telling me here? Who do I talk to? The elected leaders, the hereditary guys? How do I involve these communities? So research, evaluate, strategize, present. In terms of the communication piece, we like to talk about Columbus, because the Columbus story in our business and our world of public participation, it's all about communications and engagement. And the Columbus story is a good one because it shows you how the words we pick sometimes can really offend people. So when you look at the time Columbus arrived, we changed from discovery to arrival It's a whole different conversation. And I mean it because if you look down in the U.S. on Columbus Day, quite often there'll be protests. As Denver a few years ago, over 80 arrests, American Indians protesting Columbus Day. Has to do with the language. At the time Columbus arrived, it's estimated that 1/5 of the world's population was already living in North and South America. That's about 100 million people, 1492. The mean population average 1492 for the Americas. So from the perspective of that 100 million people, they find it really hard to understand how you can discover something when there's already 100 million people living there. To them, it's not a new world, it's a world as old as time itself. It goes right back into creation. And so they literally believe they're in the place in the world that was given to them by the Creator. It's theirs to use to protect the benefits of the values of sustainability, fit right into that worldview. And so the Columbus story is a good one for cross-cultural communications. We want to pick better words, and I'm bringing it up because some of the things that we can do to really make things tough on ourselves is start using acronyms in front of people. Lots of good acronyms. We're with BCH, ARD, and we're here to talk to you about the woke process, and can really be interpreted poorly for you. They can be sitting on their side of the fence going, they're talking code in front of us here, Bob, I don't trust them already. And so now you're just breaking stuff down, right? Colloquialisms, oh, you know what, I'm low man on the totem pole back at Hydro. I can't really give you an answer to that question. That's what I call add an hour to the meeting comment, and not really the kind of hour you want to have. Yeah, Catherine, we should get together and have a powwow to talk about that. Another hour to the meeting, not the hour you want to have. So we want to check all of that sort of baggage at the door, right?
I was in a meeting once and somebody said, can you believe this Indian summer we're having?
Yeah.
And they were like, I was like, oh my goodness.
Yeah, and it's like your harassment training. For those of you that work at the corporate sector, you get harassment training. It's not whether you intend to offend, but it's how you make people feel. That's the test that they use in harassment training. It's the same test we should use when we're doing communications with just about anybody, whether we're making them feel uncomfortable. So the colloquialisms, too many chiefs, not enough Indians, Indian time, Indian summer, powwow. The chiefs are on the warpath. Just if you ever use those, don't use them in meetings. It'll go really bad for you. Terms to avoid, back to some of the cross-cultural communication piece. Yeah, we're here to talk to you. We want to talk to you because we're going to use some Crown lands to develop our new power line, our new transportation system link, or whatever it is that you have to be. And the big problem with Crown lands right now, especially in BC, is that the Supreme Court of Canada in December of 1997 said that Aboriginal title encumbers the Crown's ultimate title. So it's not even really Crown lands. So if you want to start a bench clearing brawl, just talk about Crown lands. So yeah, we're with the government and we're here to talk to you about Crown lands. I guarantee you 4 or 5 people from the community have to jump in on that one. Yes, please. And first meeting protocol. Thanks for welcoming us to your traditional territory down here on the Lower Mainland. It's great to be in Coast Salish territory. Thanks for the opportunity to come and present. That's just the protocol. We need to find that out before we go to meetings. Easy. We never get into a community without some kind of help. Hey, Bob, I've never worked with your community before. What's a good protocol? Can you help me out with the protocol? Pronunciations. You definitely have to get the pronunciations right. Do I get credit for trying? No. You get demerits. Nobody likes stakeholders, appointee stake, pronouncing somebody's name not well is not good either. It actually can hinder you a little bit. So, call the band office after hours, listen to the recorded message, turn on your recording device, then you'll know what they're calling themselves, you'll get the pronunciation down. Ideally, if you can get somebody from the community to help you, but you get really good rapport building points for protocol and pronunciations. Can't emphasize it. You see First Nations and other Aboriginal peoples do it amongst themselves all the time. Just some of the other interpersonal stuff, handshaking. So I came from a big engineer. That was we tied it all together, gave you a little bit of a strategy, research, evaluate, strategize, gave you some good presentation tips. We talked to you about the goal of consultation. When do we know it's effective? When we can avoid the unjustifiable infringement of their constitutionally protected rights. And if we can't, then normally accommodation is required. And we'll just close on the...
Thank you to Bob on behalf of all of us. So please join me in.
Thank you, Catherine. Thank you.